How do you protect your assets in a New York high net worth divorce? When a marriage ends and millions of dollars in assets are on the line, the difference between protecting your wealth and losing it often comes down to strategy, documentation, and legal precision. New York is an equitable distribution state, which means the court divides marital assets fairly rather than splitting everything exactly down the middle. That distinction matters enormously when your estate includes a closely held business, investment portfolios, deferred compensation, stock options, or multiple properties. Under New York Domestic Relations Law, Section 236(b), any property acquired by either spouse during the marriage is presumed marital, regardless of whose name appears on the title. Separate property, such as premarital assets, inheritances, or gifts from third parties, can retain its protected status, but only when you can trace it clearly with documentation. When a premarital brokerage account is used to fund joint expenses, or inherited property is retitled in both names, courts often treat those assets as commingled and subject to division. A business founded during the marriage is generally considered marital property, while a business owned before the marriage may have its appreciation treated as marital to the extent a spouse contributed to its growth. New York courts follow a three-step process. Classify each asset as marital or separate. Determine its value. Then distribute the marital portion based on a list of statutory factors outlined in DRL Section 236(b)(5)(d). Those factors include the length of the marriage, each spouse's income and contributions, the liquidity and tax consequences of dividing specific assets, and any wasteful dissipation of marital property. A judge may award one spouse the business while offsetting that award with a larger share of retirement accounts or real estate, which is precisely why accurate valuation is just as important as negotiation. Both spouses must file a sworn statement of net worth under the matrimonial rules at 22 NYC-RR Section 202.16, detailing income, expenses, assets, and debts, supported by tax returns and pay documentation. In a high-asset case, discovery often expands well beyond that form to include document demands, interrogatories, depositions, and subpoenas aimed at uncovering the full picture of the marital estate. When financial records do not tell the whole story, working with forensic professionals to establish what the marital estate truly contains can be the difference between a fair outcome and a damaging one. Richard Roman Shum is a lifelong New Yorker and Lower East Side resident whose family law practice is built around clear, pragmatic strategy for families and business owners across Manhattan. As a dedicated divorce attorney, he represents clients whose cases involve substantial and complicated holdings, bringing focused legal strategy to every stage of the process. Contact the law office of Richard Roman Shum, ESQ, located at 20 Clinton Street, FRNT, New York, 1002, United States, by calling 646-259-3416 to speak with a high net worth divorce lawyer and protect what you have built.